first witness will be Kim Ogg, District Attorney from Harris County.
And you can call the other one up with her. Yeah, you can call the other one up with her. Yeah.
And David Mitcham. Coming up, Mr. Mitcham.
No, not these. And you can just tell them if they're comfortable, they can remove their mask. It's their decision, just so they know. Okay.
And if you're all comfortable, you can remove your mask. It's easier to hear.
Thank you, Senator. May we pass out some of these handouts to you all?
Yes, you can. And you can hand it to the messenger and they'll pass them out. It's just easier to understand you, but if you're comfortable, okay.
Yes, ma'am. I'm
Okay.
comfortable.
Yeah.
Thank you,
Okay, well,
Senator.
we'll make sure.
Just identify yourself and who you represent, and then you may proceed.
Thank you, Senator. I'm Kim Ogg. I'm the Harris County District Attorney, and I'm joined today by the First Assistant, David Mitcham. We're here today because of a crisis in Harris County that's undermining people's faith in the criminal justice system. We're joined by 4 different families who all have lost loved ones to individuals who were out on bail at the time they committed the murder that took these families' loved ones. We're grateful for the courage of these families, but we want this body to know that they are a tiny representation of the hundreds of families, if not thousands, that are grieving in Harris County right now because of the increase in violence and the impact that it's had on their families. Senator Huffman has asked me, her former colleague from the Harris County District Attorney's Office, to provide information to this Senate committee about what's happening in the criminal justice system in Harris County and what impact bail is having on public safety. My concern as the top law enforcement official in Harris County is centered on repeat and violent offenders awaiting trial while free on bond. In Texas, our Constitution guarantees bail, and current law gives judges the power to deny dangerous offenders bail in certain situations. The current law does not, however, require judges to deny bail for anyone, regardless of how many crimes they commit or how dangerous they really are. We believe that it should. Harris County is the 3rd most populous county in America with about 4.9 million people living there. We serve 22 district criminal courts and 16 county criminal courts at law. We work with 87 different law enforcement agencies, and we run a full-time intake system in Houston in which prosecutors review and prepare charges, and then appear in hearings before magistrates with the accused to state the facts of the case for probable cause findings and to make our arguments about bail. All offenders in Harris County are represented by counsel at this stage of the proceeding. In Harris County, bail is first determined by hearing magistrates and then by trial court judges. In fact, we spend a great deal of our time in bail hearings these days. And that's in large part because the jail is approaching capacity and there are no jury trials being held. Last year, 22 district courts held 5 jury trials. Judges are supposed to, under the law, consider 2 essential purposes of bond: the defendant's return to court to answer the charges and the community's safety. And it's this second public interest that is being failed in Houston under the current bail system. It doesn't matter to the crime victims today as to what kind of bond the person was on, whether it's a surety bond, a general order bond, or a personal recognizance, PR bond, requiring them to put up no money or no surety, just their promise to return to court and not commit further crimes while waiting for trial. That's why we believe that during the course of a defendant's repeated criminal conduct while on bail. We need the Texas legislature, in the spirit of this bill, Senator, to protect the public by mandating detention at some point for violent and repeat offenders on bail. It's understood that reasonable minds can differ as to how many felony bonds a defendant should or could be placed upon, but at some point, repeated criminal conduct must be stopped, even while awaiting trial, in order to protect the public. And this is where the public's interest in safety must override the individual's right to personal freedom. We brought a couple of charts that I'd like to show the committee, if I could, and they're in your handout. Never asked my first assistant to be my lovely assistant, but I think he'll serve in that capacity today. This first chart, basically, it's really simple. It just shows offenders charged with new crimes while on bond. Sometimes we hear that the recidivism rate hasn't increased. Well, that all depends on how you define recidivism. Let me just give you the data and let you decide. In 2015, approximately 3,200 offenders out on bond committed 6,348 crimes while on bond. By 2020, approximately 10,500 individuals on bond committed 18,796 new offenses. Thank you, David. Next slide. This is titled Offenders on Multiple Bonds. A new development in the bail system in Harris County since really 2018 is that we see sequential multiple bonds being granted to offenders regardless of the seriousness of their new crimes. Right now, there are 7,312 offenders who are on 2 to 4 bonds each. There are 500, and this was in 2020, there were 555 offenders who were on 5 to 7 bonds, and there were 74 individuals on 8 or more bonds at the same time. Almost all of these being sequential, meaning you go in for a crime, you're arrested, we charge you, you're released on bond, some type of bond, you commit a new crime, you come back through the system over and over. A dubious new record was set earlier this month that my colleague, Mr. Mitchum, will tell you about. We have one individual who has 18 bonds. Next slide. This is in your handout, Harris County Jail Population Pretrial Offenders. As the subject of a lawsuit, 2 lawsuits regarding bail and its constitutionality in Harris County, we often hear, we know that the jail is approaching capacity. And let me say, our prosecutors daily, after the hearing before the magistrate and after the hearings in front of district court judges, go back through the cases that came in the night before to determine who we can agree to release for, who is not violent, who does not have a violent history, who is a low risk. And we agree daily to additional bonds for people because we too understand the impact COVID has had on our system, and we are trying to flex. What we can't do is flex the community's safety out of the picture. So what you can see from this population chart is that our jail is full of predominantly violent and repeat offenders. Over 5,000 individuals currently in the jail are charged with some type of aggravated assault or higher, meaning murder, manslaughter, robbery, sexual assault. So our violent crimes, I think, are what we would all agree on we wouldn't want to happen to anyone. We also have 944 individuals charged with burglary, fraud, and property, and I assure you these are not one-off burglary, frauds, or property. To remain in the Harris County Jail at this time, you have to have a significant criminal history and have committed significant number of crimes to be awaiting pretrial. The rest is detailed for you to see. And in terms of the drug offenders that are in, we are currently engaging in a triage program to try and move those offenders faster through the system and out of custody. Thank you, sir.
Can I
Next
just-
one.
oh, may I ask a question?
Madam
On
Chair.
that chart, how many are in the jail for any type of drug offense? Is that 696?
696.
And that could be from a large amount of drugs? I mean, you don't have people, that would be, you wouldn't have for a joint or...
No one is in
Just
jail
wanna make-
in Harris County for a joint because our law enforcement agencies agreed with me in 2017 to stop arresting for possession of marijuana, up to 4 ounces.
So this fallacy that we hear that if only we would clear out the jail of people smoking joints, then,
Misinformation.
okay, thank you. I just...
These cases are almost all controlled substances where other felonies are charged. There are, I have not seen any individuals currently in jail who are just charged with PCS alone, possession of controlled substance, absent a significant history of violence. So we are working on this population to move it. But I can tell you, our jail is approaching capacity. It is full of dangerous offenders. PR bonds is next. I think one of the things that really angers victims, and it's understandable when you look at it from their perspective, is that we have a number of offenders out on personal recognizance bond, violent offenders. I agreed and, in fact, instructed our prosecutors, which was revolutionary in Harris County, in 2017 to ask for PR bonds for misdemeanor offenders who were not violent. That's what I ran on. That's what we did. What we saw was that no one was being detained, or very few people were being detained. And so our position on bail, as the facts changed, our position changed. We really have always had the same position about violent offenders. And I've always had the same position about low-level misdemeanor offenders, nonviolent misdemeanor offenders. And today we agree to PR bonds on some felony offenders who pose no risk. As I told you, we perform a daily review. So I believe in the concept and the constitutional right of an individual to be free, but it's got to be balanced with the public's safety. And finally, the last slide, which is that we see an increase in the severity of the types of offenses that people on bond are committing. We see that homicides committed by people on bond, 72 homicides in the year 2020 committed by people on bond, as compared to 37 in 2015. Rapes are up as committed by people on bond, from 23 to 92. Assaults have gone committed by people on bond from 657 in 2015 to 3,028 in 2020, and robberies from 231 to 634. Crime is up, ladies and gentlemen, and it is associated with bail. Thank you, sir. As the Harris County DA, my concerns are really about the setting of bonds over and over for sequential violent offenders. There must be a hard stop. So I support the spirit of Senate Bill 21, and I want to thank the senator personally, my former colleague, for bringing this bill to help the people of Harris County. We will provide whatever information this committee requests. We will do it as timely as possible, and we appreciate your attention. Public safety shouldn't be a political football. The senator and I are from different parties. We have a common interest. We believe that government has a duty to provide safety for people, and I know everyone on this committee agrees. And so we believe that courts benefit from guidance in the law, that you can get more consistency from judges across the state if there's just a hard stop somewhere on the continued release of violent and sequential offenders. You know, right up the street from me is the federal courthouse in Houston, Texas. And when a person is charged there's a simple decision that federal judges make. Are they too dangerous to release, or should they be released? Period. Preventative detention is what it's called. Our juvenile system uses the same thing. Whatever this committee arrives on will be an improvement, we believe, and we can only hope that at some point you all will assist the law and the judges of Texas in giving them a hard stop when repeat offenders who are violent must be held without bail. We hear all the time that this is a scare tactic or that these are outliers or one-offs. I assure you, they're not. Our 350 prosecutors are in the trenches each day with real victims like you'll hear from today. And these are real cases with real people. We very much appreciate your time.